is dependent upon statute. Statute जहां मेंस रिया नहीं भी है, but because of your act, some loss have been suffered, some act or omission has been done which is not as per the statute provisions, you can be liable to penalty. And look, section 73 is one of the examples of it. So कहां मेंस रिया चाहिए? अरे जहां words used है ना, fraud, intent to evade, section से वहां मेंस रिया चाहिए. हाँ, मेंस रिया होगी तो पेनल्टी की क्वांटम ज्यादा होगी. 73 में पेनल्टी का क्या क्वांटम है? 10%. 74 में पेनल्टी का क्या क्वांटम है? 100%. So it is the statute that defines. Now let's see it with the help of Supreme Court judgment. Supreme Court said mens rea means guilty state of mind. Mens rea is not an essential ingredient for the civil wrong. So आप जो कहते हैं ना कि भाई मेरी गलती से ये काम हो गया, मेरे से गलती से ये सेल छूट गई, it was bona fide, even then 73 proposes 10% penalty because mens rea is an essential ingredient for the civil offences but not for the criminal offences, not for the civil offences. So what you need to check, sir, civil है या criminal? पतंजलि में ये भी point discuss किया गया. What you need to check, offense कैसा है. Second, language of provision कैसी है. आपको पता है पेनल्टी के हर स्टेज पे मेंस रिया होनी चाहिए. I will prove this. चलिए एक अच्छा पहले हम लेवी देखते हैं. लेवी में वर्ड लिखा गया है, if the invoice is not issued in a proper manner, it is no mens rea required. ठीक से invoice issue नहीं किया गया, 125 क्या कहता है? माइनर ब्रीचेस, माइनर पेनल्टीज. अब अगर मैं टर्म यूज करूं falsified invoice, that shows mens rea is required. Fake invoice, mens rea is required. If I say 100% of the tax evaded, mens rea is required. If I say 100% of the tax required to be paid, mens rea not required. So जो आप 74 के नोटिसेस आते हैं या पेनल्टी के नोटिस आते हैं, मेंस रिया है या नहीं, ये प्रूफ किसको करना है? डिपार्टमेंट को करना है, मुझे नहीं करना. The person who is putting the charge, we have the judgment of Honorable Supreme Court in Uniworth case, which says that the burden of proof lies on the department. but हम मांगते ही नहीं है. We do not ask it at the lower stages. Why we are waiting for tribunals to come? जो पॉइंट आज ऑफिसर नहीं सुनता है, वो ट्राइब्यूनल उन पॉइंट्स को एड्रेस करेगा. एंड IT80 and the CSTAT has been a best example for the same. Extended period of limitation पे CSTAT ने कितने सर्विस टैक्स के नोटिसेस क्वॉश किए. क्यों? आप उन्होंने नोटिस इशू किए. अच्छा सर 7 वाले को जरा हिला के जगा देना. गुड मॉर्निंग सर. नहीं है, खाना अच्छा खिलाया गया होगा, सो हम समझ सकते. मैं नहीं कहूँगी मेरा सेशन बोलेंगे इसलिए
खिलाया गया होगा मींस.
सो व्हाट आई वांट टू हाईलाइट इज, अगर
खाना बढ़िया नहीं है,
आपको सामने वाले से मांगना है एक्सटेंड. अच्छा कितने लोगों ने सर्विस टैक्स के नोटिस अटेंड किए कि 26 ईयर्स में इनकम आ रही है और आपने सर्विस टैक्स की रिटर्न में उसमें सर्विस टैक्स नहीं पेड, राइट? डिपार्टमेंट का 1 साल का टाइम पीरियड निकल गया, सबको 5 साल का लगा के लिमिटेशन शोकॉज नोटिस इशू किए गए. वी हैव पुश कंस्ट्रक्शन, Lloyd developers and a long list of CSTAT judgments which says a particular thing which is already the part of my financial statements, which is already part of 26 years of document which is available on the public domain, how it can be suppression? छुपाया क्या मैंने? And that too suppression within, अकेला suppression गलत नहीं है. Suppression with an intent to evade tax calls for 74 or 1 for the penalties, higher penalties. But who will prove intent to evade? Department. Did you ask कि आपको कैसे लगा intent to evade? जितने notices आ रहे system generated है. I yesterday checked a judgment which mentioned system generated notices calls for कि 200% पेनल्टी लगा बोलते अपील में नहीं करवाने. Am I right? So why, where there is a e-mail on record, where there is e-invoice on record, a mismatch of a number, how it shows there was an intent to evade tax? We have Supreme Court ruling on it, Satyam Shivam paper mills, where even the cost was levied on the department for presuming the men's. कोई गलती हो जाए उस पे आप पेनल्टी लगाओ, ऐसा जरूरी नहीं है, बट ऑब्जेक्शन मस्ट फ्लो फ्रॉम यू. सर आपके पास कोई हथियार नहीं है सिवाय मोबाइल की जो गिरीश सर इससे पूरा चला रहे हैं. आपका हथियार आपका रिप्लाई है. लोअर स्टेजेस पे दिया रिप्लाई, ट्रिब्यूनल will ask you a question when they will dispose of your cases. Did you raise this objection at the first stage? Yes, I raised it. Where is the reply? This is the reply. I was asked when I paid for the refund case. आपने ये points अपने officer को दिए थे. I said yes. RFP 09 is the reply to that. And what has been his pointers on that? We need to consider that. All right. चलिए. So in taxation, penalty follows the what is the crux? Mens rea is not an essential ingredient of taxation statute. It is the taxation statute, the statutory design, use of the word intent to evade, use of the word fraud, use of the word falsified invoice, that leads the way whether mens rea is required or it is not required. Right? Chaliye, now we move forward. Even what are penalties? Penalties are the teeth that are being given to the legislation when certain non-compliances are made, maybe with or without the mens rea. Without mens rea, 73 is the example. With mens rea, 74 is the example. Now, what are the basic principles? Minor breach, minor penalties. Do the department adheres? No. I have already given you the circular 64 example. The degree of breach and the degree of the punishment must commensurate. So, what is the next one? Sir, 75, one of the prominent section which is generally missed. अच्छा, आप एक reply file कर रहे थे. आप एक reply file कर रहे थे, and there was an option personal hearing required or not. और आपने उसमें लिखा personal hearing not required. Officer has proposed an addition. Now tell me, personal hearing not given because not asked by you. You have particularly mentioned no personal hearing required. Is officer bound to give you personal hearing?
Yes, madam.
Exactly. 75(4) says, where any adverse decision is contemplated, where request is received in writing from the person chargeable, or where any adverse decision is or. Even if you say no, when any adverse decision is contemplated, they are bound to give you personal hearing. And what is personal hearing? Is it a luscious candy? Answer is no. वो बच्चे को दिखाते ना, डेट दी गई है 16 को आ जाओ, 18 को आ जाओ, 20 को आ जाओ, 3 hearings given. No, the courts have highly come upon the issue. Personal hearing means effective personal hearing. It's not like 16, oblique 18, oblique 20. I have given 3 personal hearing. And the personal hearing points and the addition points and the show cause points must be in line with each other. Many times it has been seen. In one of the case, department में rice का case बहुत चलता था ना, branded है, non-branded है. डिपार्टमेंट ने पार्टी से सारे डॉक्यूमेंट मांगे कि ये तो रिजेंबल करता है ब्रांड. पार्टी ने दिया, मेरा ब्रांड अनरजिस्टर्ड रहा, मैं 5% के लिए लायबल हूं. ऑर्डर के ऑर्डर आया, एडवर्स ऑर्डर था. एंड यू नो व्हाट वाज द पॉइंट? द डॉक्यूमेंट व्हिच हैज बीन सबमिटेड बाय यू हैज बीन मैन्युअली एडिटेड. Hence, it seems it is a temper-tainted document. Therefore, the benefit of appeal was not allowed. Was the show cause notice issued to the party, giving the opportunity to explain the point? Answer was no. And it is a fair case for High Court when show cause notice and order are not in line. When a proper opportunity, we will see a number of High Court and Supreme Court rulings where maybe oaths sugars, milks, and number of cases which says a proper hearing must be given. Speaking order. It's not a term. It should actually be speaking. What is the speaking order? अगर आपने 5 points दिए हैं, officer must rebut those 5 points if he wants to make a decision. Merely writing reply not sufficient, not satisfactory is not a speaking order. आप बोल रहे हो कि मेरे पे पेनल्टी इतनी लगनी चाहिए, means he must rebut those points, he must counter those pointers, right? Moving ahead, let me go to the section, and this is 75-30, the one I used while explaining the example. One penalty for one default. जो ऑफिसर 115% लगा रहा था, 75-30 came to my rescue. A very well grounded, और अभी इसका यूज भी बताऊंगी that how it will be turning up. Now, sir, what is the point? See, 122 section में और एक practical case study बताऊंगी. अच्छा, थोड़ी सी case study बताऊं. चलिए, actual case है, case study नहीं. पार्टी के ऊपर चार्ज था. बिल दिया है X को और माल दिया है Y और क्वांटम इन्वॉल्व वाज 500 दिया. चलो 500 रुपए माल 500. Now can you imagine कि डिपार्टमेंट ने उस 500 के क्वांटम का कितना बनाया? 3500 करोड़. And how come? I will show you through an example. And how then these sections will help us to come out of that. Now have a look. Section 122, there are 21 offences that are being listed. See, offence and default are two different terms. Huh? Every default is not an offence. Offence means something grave, and default means कोई गलती हो गई. Again, the usage of the terms define mens rea है कि नहीं, right? Now there are किसी में refunds के लिए, records के लिए, transportation के लिए, tax credit के लिए. So there are 21 offences that are given. अब ये 21 offences में कहाँ का गया? Please you read the term. Taxable person. Sir, we need to be vigilant